Hello, everyone, and welcome back to our podcast ABNR. Today, we would like to explore deeper on the arbitration world, as more and more businesses are leaning towards arbitration to settle their disputes. I think it is crucial to understand the ins and also outs of this process. Now, for today's topic, we will discuss more about institutional arbitration. And we have a very special guest today. We have Theodoor Bakker as an experienced arbitrator, as well as our Foreign Counsel here at ABNR. And we also have Adithya Lesmana making his second appearance here at Podcast ABNR as our senior associate. Now, before we delve into our conversation, I think it's best for us to introduce our speakers first to the listeners. So maybe Theo would want to start first.
Sure, I'll do that gladly. My name is Theodoor Bakker. I am by birth a Dutch national, but I've lived in this country with so much pleasure for so long that I feel myself at least partly Indonesian. I studied in Leiden University in the Netherlands and came here in 1984, working with the other partners here at ABNR. And I now, as Reza said, specialize in international commercial arbitration.
Thank you, Theo. Maybe Bang Adit would like to reintroduce himself to the audience.
Yes, thank you. My name is Adithya Lesmana, and I have been here with ABNR for 14 years now. I specialize in dispute resolution and also commercial litigation. So we're going to talk about dispute resolution, particularly about institutional arbitration today. So I can give one or two things about it.
Okay, thank you so much. Now, before we start, I think it's best for our audience to know first what exactly is institutional arbitration.
Well, a commonly used definition of institutional arbitration is an arbitration process that is organized and administered by an arbitration institution. This is in contrast with the so-called ad hoc arbitration, where the role of the parties is more prominent. And in fact, the parties are free to determine whatever rules they wish to govern their arbitration. Why is it institutional arbitration? Because the institution is organizing and administering the arbitration process. In institutional arbitration, parties decide in an agreement to incorporate the rules of a certain institution, and the institution will become the administrator and the organizer of the entire arbitration process.
Now, is there any specific dispute resolution that can be resolved by an institutional arbitration?
Yes, the rules usually include the procedures that will encompass the entirety of the arbitration process. The nomination of an arbitrator, the proceedings, and also additional features that may only be unique to the institutional arbitration selected. Depending on the arbitrability of the case, but usually all types of commercial dispute resolution can be settled by institutional arbitration. Some arbitration institutions do not have any specialty and generally accept all kinds of arbitration disputes. Some renowned commercial arbitration institutes are BANI here in Indonesia, the International Chamber of Commerce, ICC, the Singapore International Arbitration Center, SIAC, the Hong Kong International Arbitration Center, or the London Centre of International Arbitration, also known as the London Court of International Arbitration. Some institutions specialize in specific fields. For instance, the Singapore Chambers of Maritime Arbitration, as the word says, and the London Maritime Arbitration, they focus both on maritime disputes. The Court of Arbitration for Sport, the CAS, is an independent institution that facilitates the settlement of sports-related disputes through arbitration or mediation. A far more important and well-known institution is the International Center for the Settlement of Investment Disputes, ICSID, in Washington, that focuses on investment arbitration, i.e. an arbitration between an investor on the one hand and a host country on the other hand. Now, in Indonesia, I've been told there are several arbitration bodies that focus on specific fields, such as the Lembaga Alternatif Penyelesaian Sengketa Sektor Jasa Keuangan, that focuses on several limited fields, such as banking, capital markets, insurance, financing, venture capital, financial technology, used to be BAPMI, BMIA, and the Badan Arbitrage Keolahragaan Indonesia, BAKI, that focuses on sports disputes. Badan Arbitrage Syariah Nasional, Basyanas, is an institution that focuses on Sharia economic dispute resolution. And I think I should stop there.
Thank you, Pak Theo. I heard you mentioned about some additional features. What are these additional features, Pak?
Now, some institutional arbitrations have different features that distinguish themselves from other institutional arbitration procedures. Let me give you an example. Some institutional arbitration has emergency arbitration in it. The word speaks for itself. It is used in all cases where there's extreme urgency with the decision. Other institutions know, for instance, the feature of an expedited procedure. That's not emergency, but it is a short-form procedure that requires completion of the whole arbitration within 6 months. And in SIAC, it's actually standard. Even if the parties have decided on a regular arbitration, still SIAC will force the expedited procedure to be followed.
Probably in several other institutions, for example, like in ICC, they have a process called a scrutiny. So basically the award, when the draft award is being decided by the tribunal, it will be then given to the panel of an expert. So the award itself will be further scrutinized. So it ensures the standard of the award itself would be par to the standards of the ICC itself.
Yeah, I'm glad you mentioned that because you used the word standard. That's important because in the scrutiny procedures that are in place in ICC and SIAC, the scrutinizers will not actually scrutinize the outcome of the award, but it will make sure that the procedures that are prescribed in the rules of that institution are closely followed and not deviated from.
Yeah. I think I probably want to add, probably in Bani, like you have also experienced yourself. So in Bani itself, when the parties have submitted their dispute to Bani would usually encourage the parties to have a mediation prior to the arbitration proceedings itself. And in some cases, the mediators themselves manage to make the parties settle before they can go on in the arbitration proceedings. So so the award itself is a settlement between the parties. So I think these are the additional features that might not exist in several other institutions.
Thank you so much for the explanation. Now, that is a very interesting fact, actually. But what are the advantages and maybe disadvantages as well that comes along with institutional arbitration?
Yeah, I would say the advantages and disadvantages would highly subjective. because it usually depends on the party's preference and specific requirements of having a specific set of rules embedded in their commercial agreement. However, it can be argued that when you're choosing an arbitration institution and to help administer and organize an arbitration, you would have an assistant in organizing sometimes a very complex dispute between the parties. It also offers structured framework and regulations that are quite common in business people now that more and more people have chosen arbitration. Now, more prominent arbitration institutions which have been chosen by a lot of parties, they will feel more secure in ensuring that when they have a dispute, it will be handled properly. So the outcome itself would be satisfying to all of the parties. But of course, arguably, the disadvantages that I would say that it comes with a certain cost, because the administrative procedures and the administrative costs associated with institutional arbitration would sometimes translate for a higher cost compared to the other more common type of dispute resolution.
Yeah, perhaps I can add to that a very important advantage of institutional arbitration is the fact that the necessary work has already been done when the parties start. If you look at most agreements that have an arbitration clause, it's very short. It's 3 or 4 sentences. But behind those sentences is a whole body of regulations, and in the case of institutional arbitration, it is a set of rules that has been in existence for many decades and that constantly get renewed, modernized, and made more responsive to the requirements of international commercial world.
Now, we've mentioned some institutional arbitration that was, for instance, in Singapore or London, but what about the institutional arbitration in Indonesia itself? I'm curious to know more about it.
Yeah, well, I think I should leave that to Adit as the Indonesian lawyer here.
Yeah, that's right.
I think the most widely known and probably the most widely used arbitration institution in Indonesia is Badan Arbitrase Nasional Indonesia, or BANI. It was I think it was established in 1977 by the Indonesian Chamber of Commerce, or Kadin. And based what I understand, it has adjudicated more than 1,000 cases since its inception in 1977. Based on my experience, it also the most widely used arbitration rules when parties enter into a commercial agreement. And in 2022, I understand that BANI has updated its rules to accommodate remote arbitration hearings. Now that it's getting more prominent, where parties in separate locations can arbitrate. So it doesn't need to they don't need to come to a certain place to arbitrate. But other than that, the parties can also choose other rules which accommodate their needs and their preference. Based on my experience, I have been involved in ICC and SIAC arbitration proceedings in Jakarta, Indonesia. So that can also be chosen by the parties should they consider that it is suitable for their preference.
Oh, that's very convenient for people who want to choose Indonesia. Now, we have many, of course, but I'm also curious, Bang, about the recent updates about in arbitration in general, I think. What are like the recent updates that we should know?
You mean institutional arbitration?
Yeah, that's right.
Okay, yeah. Well, the most recent development in institutional arbitration occurred on the 1st of January of this year, when SIAC, the Singapore Arbitration Center, in fact published a new set of rules. And it was a substantial change. For instance, the number of rules was increased from 41 to 65. And it includes redrafted provisions aimed at enhancing clarity and better alignment with the procedural flow of your typical arbitration. So that was a significant development. Some new features were introduced in the new SIAC rules. For instance, there is a streamlined procedure created, which allows for arbitration of small and relatively insignificant matters to be arbitrated in a very short time frame. It's the step before you get to expedited procedures, which is a procedure for cases which are slightly larger and have a more significant financial interest. But there are many other features of arbitration that get put in the institutional rules, and that allows the party to proceed with their arbitration according to a fixed line. They know beforehand what can happen, and they know beforehand how they can defend themselves in situations that occur. So that is the big advantage of institutional arbitration over ad hoc arbitration.
Thank you so much, Batteo. That's very interesting. But can you also tell us any interesting stories that you have as an arbitrator throughout your career? Or maybe Badi would like to share as well, but maybe let's start with you, Batteo.
Start with me. Well, there have been and in fact, every arbitration has its very interesting sides and elements, but one particular one that I remember was in my early days when we had two parties before the arbitration was started. There is a form of discussion between the parties, assisted by their lawyers, on the procedures. And that involves also the arbitrators. So the parties had actually agreed to unquittal arbitration. But in unquittal arbitration, the fees of the arbitrators are not fixed. So they had to negotiate the fees, and the arbitrators came up with a very, very large hourly rate for themselves. And both parties were actually not only surprised, but also offended. What they did was something very smart. And we heard this a week later. They said, both parties, we withdraw the arbitration under unquittal, but at the same time we start a new arbitration under ICC rules. Now, why was that smart? Because under ICC rules, the fees of the arbitrators are fixed. So you are protected against greedy arbitrators that want to charge these high fees. I must say, these arbitrators were both from London in the UK, where arbitrators' fees are extremely high. But you would pay an arbitrator in London a multiple of the hourly rate of an Indonesian partner in a large firm. So we could, and I was the only arbitrator that wasn't from a large firm. And I actually objected to this large amount, but I was overruled.
Yeah, probably I can share this, I think, share the same experience with Theo when we had handled an arbitration case where our client was the party, and back then I was still in junior associate. I was asked by the senior to contact and to organize the arbitration itself. And I was very green, and I was not really had no experience in proceeding an arbitration before. But I was assisted by the secretariat of the institutional arbitration at that time. It was ICC, who managed to help me to get me to know the procedure and what to do, and try to assist me in organizing the venue and organizing the proceeding itself. So it was very enlightening experience, where the institutional arbitration has been very much accommodative in having these arbitration proceedings. Now they're very pro in their field, and I was a junior associate at that time, and I was very much assisted by them. So I think that's my experience.
Okay, well, that wraps up our discussion on institutional arbitration. We've explored its key aspects, from its structure and advantages to its role in resolving various types of disputes. Now, a huge thanks to our speakers, Pak Theo and also Bang Adit. Thank you very much for your insights as well as your experiences that you've shared to the audience. We hope this conversation has given you a better understanding of how institutional arbitration works and why it is becoming an increasingly preferred method for dispute resolution. Now, thank you so much, guys, for tuning in with us. And don't forget to subscribe to us and stay connected for more discussions on different legal topics. And see you guys on our next episode. And we hope you have a good day, everyone.
Thanks for having me.
Thank you.